Hi, good afternoon on the East Coast, and I'm here in Arizona. Weather is good, and I want to thank you all for coming to this lecture on representing visionary churches. It's a type of work that I've found very satisfying, and I'm going to share the screen liberally here. I've got a little presentation that we'll work through. And so I'll just start out here with a little, what should we call this? This is a graphic from a newspaper or a magazine that I actually ran back in the date that's listed up here, November 2006. And I wrote this article called Ayahuasca for the Masses. At the time, I had just discovered the emergence of the widespread interest among Americans in the ayahuasca phenomenon, and I was fascinated to see that the United States Supreme Court, as we'll be discussing further, was very receptive to this idea with a unanimous 8-vote opinion, finding that the Religious Freedom Restoration Act provides First Amendment shelter for what I call visionary churches. And visionary churches I define as churches that use a Schedule 1 or other scheduled controlled substance. But the one that is used in ayahuasca is definitely a Schedule 1 substance, and that use it as a form of communion in order to obtain a religious experience. And I'm going to refer to this as visionary communion sometimes, ayahuasca communion in the lecture. And I think it's in terms of controlling the language that we use when we're discussing this topic. I strongly recommend the use of communion because that analogy has been used in the jurisprudence that we're going to see developing as we go through this discussion. And to the next slide on. So what are visionary churches? And I am just going to blow this up here that we're looking at with this is just a search on DuckDuckGo, which is like Google, a search engine for. I think I just searched for ayahuasca retreat, and I got here 12 best legal ayahuasca retreats in USA. Now I'm almost sure that that statement is made without legal vetting and could probably expose the advertiser to some kind of repercussions. That is exactly the sort of publicity that I think it is still quite unwise to seek in this space. But if we look also at look at these various videos that are shown here, the shaman and ayahuasca journeys to sacred realms, ayahuasca, a journey to the soul. Richard Doyle, Darwin's Pharmacy, psychedelic ayahuasca journeys, the 4 phases of an ayahuasca journey seeker. This gives you an idea of what kind of people or what kind of experience people are looking for when they decide that they're going to take an ayahuasca journey. And when you consider that a lot of times this involves a costly trip to South America, not so much these days, a very important field of practice will be, I don't know if it's going to boom. That pretty much depends on the legal profession. I think the clients are there. They are intelligent folks who are very interested in getting legal services. There are just few lawyers who are capable of providing them at this time. So this is what you might think that the clients look like. I really love this picture. This actually was, in fact, taken in what was my living room before I went to law school, about 4 years before I went to law school. Gentleman in the center with the silver guitar, actually not quite the hippie he looks like. He's more like that long-haired country boy that you ought to leave alone. The woman over on the left, Rainbow Lightning, an early feminist, and generally a fascinating crew of people. Back in the background, you really can't see him, but there's a gentleman back here that right over here in this section right here, who is actually a Sprouts entrepreneur and so Sai Baba devotee. And in fact, many of these people might have gone on to become interested in ayahuasca, but probably they look a little different. I've got some demographics to share with you here about what visionary church members actually look like. And I obtained this information by conducting a survey of one of my clients. I call it the congregation. And we sent out around 1,600, 1,500, I believe, questionnaires via email. We received a 268, is around 17% response rate. That is statistically reliable. So we went and drew some statistical conclusions, summarized them here. I thought the most fascinating thing really was the age. 71%, as you'll see if you look at the top line under demographics, 71% are over 30 years of age. 46% are over 40, and 15% are over 50. This is a very mature group of people, and the pie chart makes it graphic. You can see that we've got this 40 to 49 age group constitutes 31%. If you take the total of these two groups, the orange and the red, you'll see that most of these people are between 30 and over 56%. 56% are between the ages of 10 and 50. So who they are looking for and what are they doing with their lives? 96% of them pray or meditate. And then ayahuasca is central to their spiritual practice. 96.7 have only used ayahuasca in ceremonial practice. 91.1 participate in AYA ceremonies. This is the congregation that was studied as a religious or spiritual practice. 97.6% say ayahuasca is essential to their ceremonial experience. And then there are some additional details there. Down at the bottom, I think this is very important when we are looking at the question of what is a service that the clients need. And if you look at this heading, congregants limit their speech about their ceremonial experience. You see that 69.7% hesitate to tell others of their experience via questions surrounding the legality of ayahuasca. And further, 54% virtually hesitate to family or close friends about ayahuasca because of questions surrounding its legality. So, proceeding on to who are some visionary church leaders, I'm just going to introduce you to the two big names in this space. And these gentlemen are, on your left, Jeffrey Bronfman delivering a video speech. And Jeffrey Bronfman is a Seagram's heir, a little more discerning in the causes he chooses to support than his sister, who is now headed for the Bureau of Prisons for having been a recruiter and donor to the what was that, NXIVM cult? I don't think I've said it correctly. But Jeffrey is quite the gentleman. I've had the pleasure of speaking with him on a couple of occasions. He is extremely well-versed in all the legalities and history of the visionary church field, and is certainly one of the godfathers of the movement because of his championing of the UDV's fight all the way to the Supreme Court, which provide us with the decisions that we'll be discussing in a little while. On the right, you see Jonathan Goldman. And Jonathan is leader of the Santo Daime Church, based in Ashland, Oregon. And he was arrested in, I believe it was 1999, October 21st, 1999, I believe is a fateful day. Bronfman had a drum of ayahuasca seized in New Mexico, and Goldman had a drum of ayahuasca and his own person seized in Southern Oregon in coordinated raids that happened one day apart in October of 1999, if memory serves me correctly. Mr. Goldman, also quite the gentleman, he was represented by an attorney named Steve Haber, who's based in Eugene, Oregon. And Mr. Haber has a stellar resume, having been one of the attorneys who represented plaintiffs at the infamous Parchman Farm in Mississippi and established some reforms there, though I understand that the farm is still an atrocious place. Mr. Haber eliminated some of the most severe abuses, such as murder and abuse and slavery, that were conducted under color of law. So they have each contributed tremendous amounts of time and money to the process of advancing the law that we're going to be discussing here, and I think it's appropriate to give them due regard. The work that they've done is massive, monumental, and we who are continuing the work are just really so grateful to them to have these important constitutional precedents with respect to Bronfman, and then having taken them all the way through trial, which is what Goldman did up in Oregon, creating a trial record that all of us can view right there on Pacer to educate ourselves on how to handle these cases. So let me tell you a little bit about ayahuasca effects. We will be concentrating on ayahuasca because ayahuasca is the most popular visionary substance that is currently used, and virtually all, not even virtually, all of the successful cases that have resulted in court rulings favorable to the plaintiffs in visionary religion cases have involved ayahuasca. So I am going to read through what's appearing on the screen here because it is some fairly dense information. This is provided by Paulo Barbosa, a Brazilian PhD who very generously worked with me to develop an up-to-date summary of all of the peer-reviewed science regarding the religious use of ayahuasca. And his 5-page declaration that was submitted in support of a request for preliminary injunction that we'll discuss further later on at the end of our lecture. And I think that the summary is really superb. If you are interested in pursuing this area of law, you should definitely get a look at that. And I will share the Lexis information and Pacer information about the case so that you can dig that up yourself. But just to get to this is actually the conclusion of Dr. Barbosa's expert report. The psychoactive effects begin slowly after a 45-minute period of onset and end within approximately 6 hours. Ayahuasca consumed in a religious context is not being used as a drug of abuse, nor does the religious use of ayahuasca lead to the abuse of other drugs. Instead, religious ayahuasca users generally abandon abuse of alcohol after they become members of an ayahuasca church. And I'm just going to pause here and interject how enthusiastically Dr. Barbosa provided that information. That is the recent conclusion of some peer-reviewed science that was only completed in the last couple of years. And he was extremely excited about being able to say that there was clinically citable data that visionary religion, in particular the use of ayahuasca, actually causes clinically determined reductions in alcohol and other drug abuse. So just to resume here at the middle of the page, these data are backed up by preclinical evidence indicating that ayahuasca blocks many abuse-related behavioral effects of drugs of abuse. Ayahuasca does not adversely affect mental health. Many religious ayahuasca users start out with greater psychological morbidity than the control group and show a marked improvement with years of ayahuasca use. And I'm just going to pause there because the word psychological morbidity is not something that we commonly use. The way Pablo explained it to me was it is basically any worsening of a psychological condition away from the presumed healthy baseline. So he was very pleased to say that the evidence also seems to support this, that people actually come in with some determinable psychological problems. And after using ayahuasca, and I think over the course of about a year, as I recall, the peer-reviewed science indicated that many of these people, particularly with depression, anxiety, PTSD, would experience some improvement in their condition. Resuming now from the text of Dr. Barbosa's summary, reporting greater mental health after participating in religious ayahuasca use compared to control groups. Ayahuasca has not been observed to impair cognitive function, and on some testing scales is associated with improved functioning. So I'm going to just unshare. Oh, I see that I have not been precisely sharing my screen. Let me go back through my slides. I apologize for not having accomplished what I intended there. That's okay. This was the slide I was about to show. Okay, very good. So that was the slide I was about to show, but I'm just going to go back to the beginning because I had so many pretty slides to show you, and you didn't even get any of my jokes. So at the beginning, we got the page from the Ashland Free Press, which I'll proudly say my son did the cover and did as well this illustration for the article, which basically was an introduction to the law of representing visionary churches as it stood at that, which was simply that the Ocentro case, the Gonzalez versus Ocentro case, had first been decided, which was, I believe, in 2008. What are visionary churches? This is what I was thinking I was showing you earlier, and I particularly focused on this right down here, 12 best legal ayahuasca retreats in the USA. And that is exactly the sort of thing that you will find whenever you use a search engine to find information about ayahuasca. It is being marketed really actively. I don't think it should be turned off by the marketing. I think it's quite natural for these groups, and it does not indicate any kind of merely monetary incentive, though I think monetary incentives color religious activities a lot, and the interfusion of the two is something we're comfortable with in other religions, and I don't think there should be any difference with ayahuasca and other visionary religions. Generally speaking, I haven't met anybody who is making bank on visionary religion, and I haven't met anyone for whom that was their primary goal. But I have met plenty of people who market using the internet and make representations about visionary religion that it would be good if they were legally vetted. This was what was supposed to make you laugh. What you think visionary church members look like. This was the gentleman I was describing. You were like, what is this guy talking about? Then here are the demographics that I wanted to show you. And we can zoom in on those so that you can see what I was talking about earlier when I said that there was an orange and a red part of the graph, which showed that 56% of the people were between the ages of 30 and 50 who are participating in ayahuasca practice. I did read through a lot of these numbers here, but I think that you can just see just from scanning them that we're talking about over 90% of these congregants are experiencing and practicing ayahuasca ceremony for religious and spiritual purposes. And as I mentioned, very high percentage of people, 69.7%, hesitant to tell others about their experience because of questions about legality. So then here are the gentlemen that I wanted to introduce you to. That's Jeffrey Bronfman there, the funder of the UDV's legal efforts, which have benefited all ayahuasca churches, of the visionary churches in general. And here is Jonathan Goldman, the gentleman who's with the Ashland Santo Daime, who won the case in Oregon District Court, and I believe gained their result in 2008. And that was the Church of the Holy Light of the Queen versus Casey case that we will talk a little bit more about. Now, this was what I just read to you, and so I suppose you were able to follow that, but I'll just scroll through it slowly. Ayahuasca's effects, and this branch here, what it's showing you is a piece of the yage vine or the yahe vine, and this is one of the two elements of ayahuasca, and it is the non-scheduled part of the mix. It is the part that combines with the scheduled part to allow the psychedelic experience to happen from an oral brew. I'm not going to get into the science about it right now, but I did want to familiarize yourself with familiarize you with basic idea of what kind of substance it is, and to let you know that the peer-reviewed science is available there to help your clients prove to judges, medical authorities, the general public, and for their own benefit, how safe the substance is. That is not to say that it doesn't generate an extremely powerful experience that can include fear of death, anxiety, need to confess, a desire to forgive. It's a very, very powerful substance, and it is important that it be used in the visionary church context, in my opinion. I think that as you look into it yourself, if you develop an interest in this field of practice, you'll discover that it is very a very powerful substance, and that the setting, as the term is often used, is vitally important to produce a genuinely beneficial experience. It is not recreational substance, and if you look at the jurisprudence of it, you'll find, and I do cite it further on in the presentation, some cases that say that it's simply not a problem, a diversion problem for the drug control authorities because it does not tend to abuse. And and I think it is important to know that there is peer-reviewed psychological data that the painful and difficult experiences that definitely do occur with ayahuasca in some percentage of cases, and not necessarily a particularly small percentage of cases. This is a cathartic experience, in my opinion, that definitely can impose some stress upon the congregant. But in the right environment, that stress is, as in analysis, therapy, and in other kinds of self-work, it's ultimately beneficial, and as Paulo says, does not adversely affect mental health. So this data is there, and should it become important to you, please consider me a resource. I am definitely here to help you to find other resources if you need them, and to help members of the visionary church community, legal groups, to coordinate and develop a convincing presentation for the development of a truly new visionary church jurisprudence, my way of thinking of it. So I'm going to go back to screen share here. And here we go. Alrighty. Now, what is visionary communion? It's what is happening during the 6-hour experience, if the experience is a properly administered visionary church ceremony. What happens under other circumstances is we don't know. There isn't any useful peer-reviewed science about that. There is useful peer-reviewed science about what happens when ayahuasca is administered in the ceremonial context. And we have useful Supreme Court opinion, which I'm quoting up here on the on the screen. And sorry, I've only got the jump site here, but this case is real easy to find. Just Google Gonzalez versus Ocentro, and it comes up promptly. And here, so we have a Supreme Court definition of ayahuasca. In that case, it was referred to as huasca. Here are the two plants that usually comprise it. Psychotria viridis, which contains DMT, a hallucinogen whose effects are enhanced by alkaloids from the other plant, Banisteriopsis caapi. That Banisteriopsis caapi is the substance that was shown in the previous slide. That is a large vine called a liana, and that contains substances that are called beta-carbolines. It really is very interesting to study the physiology of ayahuasca, because dimethyltryptamine, DMT, is a very powerful psychedelic, which, however, is not orally active because it is broken down in the gut and does not reach the brain unless it is consumed along with these substances called beta-carbolines. And beta-carbolines are what is in the vine, in the liana vine. And DMT is what is in the the leaf, as it's called. And there are actually two different kinds of leaves that can be used interchangeably. They contain DMT. You can make a tea directly out of the leaf substance and consume it and have little more effect than drinking peppermint. However, if the beta-carboline containing Liana tea is cooked along with it, then when orally ingested, DMT will produce the 4 to 6 hour journey, which is used in visionary communion, instead of what DMT usually produces when it is injected intravenously, intramuscularly, or smoked, inhaled, which is the usual way in which people experience it. And it produces an experience that lasts between 5 and 20 minutes. Intramuscular injections last longer. But that is said to be a very disorienting and difficult to integrate experience. Flash, as many describe it. And accordingly, ayahuasca is a much more controllable and useful avenue. Additionally, the beta-carbolines have their own effect, which, if consumed separately without the addition of DMT, is still a mildly psychedelic substance, it is said, and will produce a sort of dreamy lassitude and dream imagery. But again, I'm just reporting from anecdotal reports that can be read online. But when the two are combined together, you get this very interesting, deeply reflective, visionary experience in which it is not uncommon for people to have visions of people who are absent, be they deceased people or people who are physically absent, but they will be seen as present. There are often communications, reconciliations with persons with whom one has had difficult times. One of my clients works extensively with veterans who have combat trauma, PTSD, and he has told me repeatedly that he's dealt with many people who were on the verge of suicide, were deeply sincere about ending their own lives, but were able to start again and purge the painful feelings that they are suffering from PTSD through ayahuasca healing. And so I think it is very important for attorneys who are interested in this field, not necessarily to take any substance, not at all. There's a tremendous amount of literature out there. If you find it interesting, then I think you got an answer for a big problem that a lot of us suffer from as attorneys, which is we don't like what we're doing. I spent 30 years doing various different kinds of work, and I have never enjoyed myself as much as I enjoy what I'm doing now, because I genuinely feel that I'm working with people, whether they're right or wrong, believe that they are making the world a better place, and they do seem to be making themselves better people, as far as I can tell. Their conduct and behavior seems pretty good to me, and they seem to be having the right attitudes toward what I consider to be species level crisis that, frankly, the legal profession has helped to bring on because we've provided most of the structures through which our economic and environmental problems have arisen, and I think it's our job to help society to recover from some of the mistakes that have been made that way. So now, toward the end of my career, maybe it won't end so soon now, because I'm enjoying it quite a bit more than I had the previous 25, 26 years. So it's my pleasure to share this kind of information with you again. I do offer myself as a resource to you, and I think it would behoove you, if you're interested in this space, to bone up on the chemistry, particularly of ayahuasca, but there is a much broader field of natural healing substances that are being recognized, and we'll discuss further the legalization movement. And I'll get back to the slides so we can do that. Okay, so let's go ahead and resume discussing some of the legal background. Move on to the case, the Church of the Holy Light of the Queen versus Mukasey, which I mentioned, Oregon case. I see we got the main decision on 2006, a fascinating decision by Judge Panner. And a little background on Judge Panner, who said, the Santo Daime Church brews Daime tea in Brazil in elaborate religious ritual. Men gather the woody bee capi vine, pound it for hours with mallets. Women collect and clean the viridis leaves. Shredded vine is boiled for many hours. P. viridis leaves are not added until boiling is nearly complete because the DMT dissolves rapidly. So obviously, Judge Panner understood how ayahuasca was made. He ended up understanding, thanks to the extensive submissions of the Santo Daime Church that are all on Pacer, and you can download and read them, and the extensive submissions of the DEA that attempt to refute Goldman's claims of safety, and they threw the book at him, trying to make him be a drug dealer, drug user, and all of these arguments were discarded by Judge Panner. And when you read it, if you are a former federal public defender like myself, and in fact I practiced in the very courthouse where Judge Panner made the decision in Medford, Oregon, as a member of the CJA panel there. And it's not an easy courthouse. It's not an easy courthouse for defendants. And the fact that they got a victory from Judge Panner is a testament to the skill of their attorneys, the excellence of the evidentiary presentation that is available there for anyone to review and replicate, may I suggest, and particularly a tribute to Judge Panner, because anybody who has a background in this area of law, and particularly controlled substances, you will see that how Judge Panner ruled was definitely not the only way to rule. And so it's important to know your judge. Judge Panner, in fact, had represented Native American tribes for a number of years before he was elevated to the bench. And so he was very familiar with Native American religion and had sympathy for the people who were presenting. And you can just really see that he gave the plaintiffs a fair break, and in so doing established a really great case that the DEA never wants to replicate, I assure you. Back to the text. Okay, now, Controlled Substances Act. This is just to state the obvious. This on the left, the pot of leaves, that is some indigenous folks cooking up the leaves with, it looks like that's almost entirely leaf. The bark is probably settled at the bottom. And on the right, that is the image of the dimethyltryptamine molecule. Dimethyltryptamine is a fascinating substance, far more fascinating than this little diagram would suggest. But what is interesting about this molecule is that it's really simple. And if you study the DMT molecule, there is an excellent book on it by Rick Strassman called The Spirit Molecule. And I've had the pleasure of talking with Dr. Strassman. I reviewed his book when it first came out over 20 years ago. And he was the first experimenter to, I think, but since the 60s, to obtain a DEA license to administer DMT and perform peer review science through his experimentation. Dr. Strassman's an interesting person. He was also a Zen Buddhist at that time, ended up getting a whole lot of flack from his Zen Buddhist community for the work with DMT. And he was also surprised and bemused, as it were, as he describes in a second book about DMT and the visionary experience. He was also surprised to discover that no one seemed to be having a unitive experience of the classical Zen sort from taking DMT, something that he had expected. Unfortunately, he was disappointed. He really didn't know where to go with the experiments when he kept getting what was more like a prophetic experience, and he ended up writing a book called DMT and Spirited Prophecy, in which he hypothesizes that the primal religious experience is more the sort of wild, uncontrolled, explosive DMT type experience. Fascinating additional book. There's a lot to speculate about in the field, but the role that DMT plays in human consciousness, Dr. Strassman, really without any evidence, bless him, suggests that DMT mediates the transit of the soul into and out of the body at the time of death due to internal secretions from the pineal gland. But for this, there is only the scantest of evidence, and he didn't really add to the body of it. But, there is the additional element of the hypothesis that spirits enter and depart from bodies, which, of course, is really lacking in evidence. But the interesting thing about DMT is that it is present in the body. He's right about that. And it is present in elevated concentrations in the pineal gland, which has a purpose that is not yet fully understood. So, and DMT occurs in many plants in the animal kingdom, many plants in the plant kingdom, channeling to Dan Quayle there. It can be extracted from a number of substances. And thus, since the formula for extracting it is widely available on the internet, and the substances from which it can be extracted are also available, it's a substance that people have gotten to know pretty widely. But again, no one has really figured out why it is what we call an endogenous psychedelic, a psychedelic that exists in the body at all times, what its purpose is. But I don't think it is too unreasonable to think that it plays a central role in the generation, management, administration of consciousness in our body. And what happens in the visionary community experience is essentially an experience that is endogenous to the human animal. We can all have such an experience. And that kind of commonality, that kind of common basis for the experience shows you why, at that point, we all have one type of experience that you can say, oh, well, that might be religious. Yeah. We'll talk more about religion in a bit. Okay. So, we don't spend a lot of time talking about the Controlled Substances Act here, but there it is. It is unlawful to possess this stuff, so how are people doing visionary religion? The Religious Freedom Restoration Act. This is the vehicle by which people can obtain judicial relief. Take note, 42 USC, if that title reminds you of anything, it should remind you of 42 USC 1983 and 1985 civil rights statutes that have largely been gutted by the doctrine of discretionary immunity, which so far has no relevance to the field of Religious Freedom Restoration Act jurisprudence. And hopefully it will always stay that way, and perhaps we will get rid of the qualified immunity argument altogether. But to focus on RFRA, let us focus on this element of the test. Government shall not substantially burden a person's exercise of religion. Stop right there. What is a substantial burden on a person's exercise of religion? Is it a substantial burden on someone's free exercise of religion to not allow them to wear a beard if other police officers are allowed to wear beards for health reasons, if your reason for wanting to have a beard is religious? So you have a right to have that beard if anybody else would have the right to have that beard. It would be a substantial burden. Why is facial hair, your right to have facial hair, a substantial burden? Substantially burdened by a rule requiring that you shave it off. Those kinds of distinctions are drawn in the law, and I think one of the reasons that I always emphasize that those who wish to operate visionary churches, those who wish to share visionary religion with others and enjoy it themselves, should think of their use of the Schedule I containing substance. They should think of their use of it as visionary communion. And the reason is that this analogy to Catholic communion and to Christian communion is, I think, when you read the cases, what lies at the bottom. And we now have, frankly, we have 6 Catholics on the Supreme Court, and the Gonzalez versus Ocentro decision, so vital, the bedrock decision here, was authored by Justice Roberts, and the position expressed recently by Judge Alito at the Bar Convention, where he spoke about religion under assault from COVID regulations, that interference with the right of free exercise was in greater danger than ever before. That's not a new position. Those who think that he is embracing it for political purposes or emphasizing it should disabuse themselves of the notion. He has been a steadfast supporter of religious freedom since he was at least on the Third Circuit, and wrote an excellent decision entitled Blackhawk versus Pennsylvania, which established that religious exemptions have to be granted when they would be granted for secular purposes. And so because Barnum and Bailey could easily get a permit for free to exhibit animals in Pennsylvania, therefore a Native American man who used bears in his spiritual practice was entitled to have an exemption as well. And the argument, well, we allow secular exemptions, we don't allow exemptions for religious purposes, is essentially on its face discriminatory and has a disparate impact. So Judge Alito is actually a great fan of the disparate impacts theory that poses great promise in litigation in which, frankly, visionary churches are not given the same deference that other churches get when they make RFRA claims. They don't receive the same kind of responsiveness from the courts we'll discuss after.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Coat. C-O-A-T. Coat.
Okay. Substantial burden. So what is a substantial burden? It should be something that imposes substantial hardship, and the risk of criminal prosecution is always a substantial burden because it is directly focused on curtailing the activity that is claimed to be free exercise, in this case, the drinking of a controlled substance in ayahuasca or visionary church communion. And so let's take a look at the rest of subsection A. Government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. I'm not going to go into the history of RFRA or how it came down, but this is, of course, a really big rule. This applies to the entire U.S. Code, which is filled with rules of general applicability. This provides potentially a religious exemption from literally every prohibition in the U.S. Code. Why only the U.S. Code? Because in the city of Bourne case, the Supreme Court determined that federalism trumped the authority of Congress, and the states are not bound. So it is only the U.S. Code that is subject to this exemption requirement, and all federal agencies and their administrative regulations as well. It is not the laws of the 50 states. However, a number of states have adopted their own RFRA Act, and I'm sitting in Arizona, which has its own RFRA Act. And it is called the Free Exercise of Religion Act, FERA, and there has not yet been an adjudication as to how FERA protects ayahuasca religion. However, there has already been an Arizona Supreme Court case decided that holds that it follows, that the Arizona Supreme Court will follow the Ocentro case. However, it was in a case which is the other side of RFRA jurisprudence, which is what cynical people might call the right to discriminate against others for purposes of religious free expression. And that, of course, is the gay wedding cases and the gay wedding dress cases. And in Arizona, a case called Brush and Nib, which is the case involving two calligraphers who did not want to write gay wedding invitations and did want to put a sign on their website that said, "We will not do your gay wedding invitation." And they were notified by the city of Phoenix that violated the anti-discrimination ordinance in the city that required the provision of services to all equally without regard to gender or sexual orientation. So they took it all the way to the Supreme Court. The Supreme Court reversed the Superior Court and the Appellate Court and followed Ocentro and said, yes, they could post your sign on their website and tell all the world that only heterosexual wedding invitations would be created by brushing it. So that's as far as we've gotten there. There are additional wrinkles in Arizona law which may make FERA more challenging for visionary churches. Not going to get into them right now, but suffice it to say that a number of states did adopt Religious Freedom Reformation Act style statutes in order to subject state codes and administrative agencies to the same type of restraint that Congress imposed when it adopted RFRA. We'll go back to the text of the statute now. Okay, so what's the test? It's here in Section B. The government may substantially burden a person's exercise of religion only if it demonstrates that the application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. So, that probably sounds familiar to you. Remember something from common law class, that test. And how does it actually pencil out right now? Let's get right down to the nitty-gritty of how this test is applied today with all the jurisprudential water that has flowed under the bridge. How it's applied today is that the compelling government interest is assumed to exist, and that is called prevention of diversion of controlled substances into the illegal marketplace. And the second part of the test is the problem for the DEA. Because in addition to proving that they have a compelling government interest in keeping children from getting ayahuasca, from keeping people who are not using the DMT-containing substance for religious purposes, to keep it out of their hands. That's assumed. They don't have any problem proving that. But that total prohibition is the least restrictive means of furthering that compelling governmental interest. That's really difficult. That's really difficult. And RFRA requires that that determination be made on a case-by-case basis with respect to every applicant. And so that means that in order to carry its burden, the government has to show that in order to keep drugs out of the hands of children, it has got to prevent an entire congregation of visionary church practitioners from having their religious experience. And if you have a genuine church and you have a sincere congregation and it's properly documented, I don't think the government's ever going to be able to carry that burden. They know that. And so that's the door that you as counsel can tell clients. I don't know if you can go through that door, but if there's an earthquake, you can shelter under it. And if you want to try going through that door, definitely knock on it and try to go through it. We're working on that right now, and that's something I'd be happy to discuss with anyone who actually wants to go to court and use RFRA or their local RFRA, their state RFRA, in order to get a piece of paper that says you can run this visionary church and you can import your medicine. That also, as we'll discuss further, very important. Okay, so, and here's the kicker: judicial relief. Person whose religious exercise has been burdened in violation of this section may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief against a government. Standing to assert a claim or defense under this section shall be governed by the general rules of standing under Article 3 of the Constitution. May assert that violation as a claim or defense. So far, the largest volume of cases asserting RFRA are unsuccessful criminal defendants. I think that is definitely the largest of cases. And you should also know about RLUIPA. RLUIPA is the RFRA for incarcerated people in federal institutions. And it provides them with essentially the same rights And it has some adjudications that are of interest because they actually involve adjudications of how a court determines whether applicants are religiously sincere about their religion. And that's a really interesting topic, sincerity of religion and how it is determined in various different juridical contexts, from prison to the rest of us out here who are ostensibly not in prison, but actually have our activities considerably constrained by the potential of being put in prison, which is what that substantial burden is all about. So that may assert that violation as a claim is how Goldman and Bronfman were able to get injunctions against interference with free exercise by the DEA. And that avenue of relief is available. Every United States district court has original jurisdiction of a case. The question is whether you can assert a claim or defense under the general rules of standing under Article 3 of the Constitution. And that is going to be a question that the judge will have to decide. And in, I think, just about every case, the government is going to contest it based upon the argument that there is no risk of prosecution. And I have now been through the experience of hearing the United States government, the DEA, the DOJ attorney tell me that my clients are under no fear of prosecution in court documents, even though one of them has already actually had his home searched by Maricopa County detective and his team, who were invited to take that activity by the DEA. So standing, litigating with the government is never easy, and standing under Article 3 will almost always be litigated. So be prepared to prepare your standing case well. Key RFR precedent, and here is where the Supreme Court enunciated it. Prohibits the federal government from substantially burdening a person's exercise of religion unless the government demonstrates the application of the burden represents the least restrictive means of advancing a compelling interest. And why Congress legislated the compelling interest test? For the courts to strike a sensible balance between religious liberty and competing prior government interests. And it operates by mandating consideration under compelling interest test of exceptions to rules of general applicability. This also applies to federal regulations, Burwell versus Hobby Lobby, and applies to for-profit, closely held corporation. And that was the big surprise in Burwell. It involved the duty of a corporation to pay for contraception under the Affordable Care Act, and the Supreme Court held that the Health and Human Services administrative rule that said that only nonprofits could deny their employees the contraception benefit violated RFR. And if you want to know what kind of privately held corporation can assert a religious defense to an administrative regulation from Health and Human Services, Hobby Lobby is the example. And Hobby Lobby is a privately held corporation. And it is religious. And how did the Supreme Court determine that the corporation itself was religious? They read the bylaws and the articles and some other documentation that had been created by attorneys to establish the religious nature of the corporation. Now, it's worth noting that Hobby Lobby is not just a religious corporation. It's also a felonious corporation, something that most people don't know, because they're not discussed in the same context. The Supreme Court case isn't discussed in the same context as the New York criminal cases, in which Hobby Lobby has been accused of stocking its Bible history museum with stolen Iraqi artifacts plundered during the, what was that? Operation Desert Storm. And so don't think that just because your client might have had problems with the law at some point, that you don't have some authority to cite. There's some authority to cite that even felons can obtain full protection of the law. But I don't know that issue was raised before any court, that Hobby Lobby was simultaneously engaging in archaeological theft while it was denying its employees contraceptive benefits. Those kind of things don't always come out, but you're lawyers, so you can bring those things out.